It takes a little bit. There we go. We are being recorded.
Thank you. Now, I don't have the agenda in front of me. I don't think, I think after introductions, we were going to just jump straight into the rules, unless there's something that we should preface it with. I'd like to begin that discussion. I want to be conscious of all of your time, and thank you so much for joining us in this rulemaking. I'm hoping that we can get this done in a relatively short order. I know that many of us have a legislative session coming up in just a couple days. And so it'll be up to this group on whether or not we have a meeting in February or we want to put off and have 2 meetings in March to kind of clean this up and get it out there. It's important for me, and I would imagine a fair number of other people, to get the requirements out as soon as possible. The license isn't required until July 1st, but it's nicer to have, you know, what it's going to be out there in advance so that it's not, you know, June 30th and people are scrambling because they, you know, we didn't do our communications well enough. So that's my hurry. But I also want to make sure that we get it right. I want to make sure that these rules are workable for, you know, to the extent possible for everybody that they're workable for. So unless there's any questions on that, hopefully you all have gotten a chance to take a look at the rules. I have a slightly older version in front of me. And the rules really, at this point, do kind of 2 things. They track the statute and then they track the NMLS requirements. So there's a number of other states, I don't know, it looks like maybe half a dozen or so that have their licenses on the NMLS, and that we have found is the easiest way to streamline licensing requirements for everybody. It's nice, it's simple. Once you put the information in there, it's done, and you don't have to submit it to, you know, all 12 of us individually. So a lot of what you'll see here is the procedure for the NMLS. And then the rest of it is basically comes from the statute. There's not a whole lot in here that wasn't dictated by one of those 2 things, which is also one of the things that I would need your input for, to see if there's things, you know, based on my just bare bones draft, we're missing or that are inconsistent with how it is that the other states are administering this particular license type. So unless there's any questions. Couple of things that we do not have in the rules right now and that I will probably need to leave for a future meeting are the fees. We have not completed a fee study yet. And one of the questions outstanding there is whether or not we should do just a base license fee and then an assessment, or no assessment and just a base licensing fee. And then if we do the base licensing fee, what does that mean for branches? Branches are provided for in Senate Bill 485. And what it is that we do for renewals. Typically, with our license types, we have the same initial licensing fee as we do for a renewal fee. This upcoming license that'll be from July 1st through December 31st will be a smaller kind of chunk of it because it's only a half-year license just based on when it is that we need to have it up and running. And then the statute provides that all licenses expire December 31st. So we're not really at liberty to play with that. In terms of, and thank you, Karen, for pulling up the rules here. We've got the application requirements, and for those of you familiar with the NMLS, you can really track, it's the M1, the M2, and those are provisions that basically talk about the control people, who it is, the directors, the managers, there's a definition for control people in the statute that aligns with the NMLS. We worked with the Department of Justice on the bill as it was drafted, so we did manage to get in a lot of the definitions that aligned already. So we've got, and of course I can't, so directors, officers, general partners, managing members of a limited liability company. Those are the folks that are filling out the MU2 with that particular information. Another provision is a person that has direct or indirect right to vote 10% or more of the securities in a business entity. Again, all those align with the NMLS and the actual bill itself. So rather than kind of just read through, I don't know, the rules, are there any questions or concerns about the application requirements? Unless it's helpful for me to read through, in which of course I can do that.
We don't have any from our organization, and I'm fine with going through these. And if no one responds in the affirmative, then or in the negative, we assume everyone's okay with the section. But I don't want to speak for everybody.
I don't see anybody vehemently shaking their heads. So okay. So then let's just kind of flip through these real quick. So 0005 is the application requirements. Financial statements, just the general requirements for the NMLS. Are there any concerns with section 6, the statement with a detailed breakdown of the portfolio of student loan servicing rights on a nationwide basis as well as separately for Oregon?
I mean, I think it'd be useful. This is Scott. I mean, it would be useful to have sort of what exactly what exactly information you'd require, right, on that statement, because some of that is obviously very easy to sort of pull together, and some can be very complicated or may not be easily accessible. So a little bit more definition around that might be useful, I think.
Okay. Do you have suggestions for what types of information would be more useful?
Yeah, I think we could, and we can share that so you can, folks can look at that. I think it would just be helpful to know what, what exactly sort of would be valuable, to the state to know here. I mean, I assume the general concept, right, is to understand sort of exactly sort of, what portfolios are being serviced in the state. But I guess the question is nationally, what it's helpful to know what is the information that would be the national information that would be useful to Oregon.
Okay. And I think part of that provision is would be useful for the purposes of an assessment. Like I said, we haven't done the fee study yet, so that we're still, that's one of the questions that we have outstanding is how it is that we're going to essentially pay for the administration of this program. That is our threshold. The bill provides that we can charge a fee to be used for the administration and enforcement of the program, but without a real good handle on how many student loan servicers we're going to have at this point, because that's not information that we really know. We know, give or take, that there's about 15, 16 servicers that have already disclosed to the NMLS that they are doing business in Oregon, but there may well be more, folks who are doing business but haven't disclosed it because so far we didn't have a licensing rule. So that's one of those questions that's still kind of up in the air. Is there anything else with regard to the application requirements that anyone thinks is missing or is unclear?
Is there an expectation that the data collection that you conduct here will be public? Is there like a public reporting scheme that you have in mind? Is that typically what you do in other markets where you do this kind of threshold data collection? Certainly, we advocate for that. I know the Department of Financial Services in New York has a pretty thorough data collection scheme for its licensed student loan servicers, modeled on a proposal that the CFPB put out back in 2017 and publishes a portion of that. I'm going to drop, I don't know if the chat's the right way to share documents here, but I'm going to drop the template that was the basis for the Department of Financial Services data collection scheme. I don't actually have the DFS one in front of me, but
thank you.
It is substantially more detailed than what's in the draft rule here. So I should just flag that. And I'm sure that Scott and will have feedback as well. But
so thank you for providing that document. And maybe this is something that we'll come back to in the next meeting once everybody gets a chance to kind of see what's there and how substantial it is. Haven will probably have a better sense of how much information we post publicly or share. Things that are available on the NMLS through the public portal, of course, is one thing, and then things that are regulator only is, and I don't have a good sense of licensing and how that breaks down.
Yes, so this is Haven. So there is a
Told you she
Consumer
wasn't a
Act.
robot.
Sorry, I'm having problems with my headset. With the NMLS, there's certain information that's available through consumer access, but it's not typically data that, like we would collect in a report, wouldn't show through NMLS. So that is definitely something we can think about, and having seeing what other regulatory bodies have done is helpful. Typically, there's very few license types where we actually publish an annual report based on the information we collect. Typically, it's information that we provide if there's a public records request, but we can definitely explore that as to what would be available, via our website, based on the information that we're collecting.
Thanks. And I'm not sure. Again, this is my first time participating in an Oregon rulemaking, but if it's helpful or necessary for us to formally request that the data you collect be published in some routinized manner, we are happy to do that. You just tell me how to best engage with that, and we'll make sure that happens.
Well, as part of the rulemaking, everybody's here to kind of discuss how it is that generally to the best that we can reach agreement is the best way forward. But that doesn't preclude either public records requests or comments later. During the public comment period. So
thanks.
So that link is exactly perfect in terms of helping us track down that information. Thank you.
So Erin, Teams, I'm having trouble with Teams. Not unusual. So I had to log off and get back on. So are we still on the same rule?
Yes.
Okay, perfect.
Yes.
Thank you.
But unless anyone wants to stay with this rule, I would have her scroll us forward to the next one, which is really the biographical information requirement. And again, this is pretty standard NMLS language for us. We need the identity of a registered agent. So there we go. And I think I skipped over, or am I just? Oh, no. I have an older draft of the rules. That's why this list doesn't match what it is that I have printed out. Can you scroll up just a little so that we can see 00110? Okay, that's the automatic licensure. And that is a provision from the bill that student loan servicers under contract with Secretary of Education automatically are granted a loan upon payment, a license upon payment of fees. So that was provided for in the bill, and we're not the only state that is doing this. I think that's a real common practice at this point, in particular to kind of address concerns with the preemption under the previous administration. I know that that's been loosened up a bit, or the interpretation has been rescinded, and a new interpretation with regard to the preemption of states is out there now. So there's not a lot of requirements for automatic licensure. It's mostly just letting us know that you're out there, notifying us that there's a registered agent, and then letting us know if that contract expires or is terminated. Any questions about that one? Karen, can you flip down to 15? And that's what I was looking for, the biographical information. Again, that basically just spells out the folks that we're looking for the information in the NMLS from, and that is from Senate Bill 485. And then I see I already have a numbering deficiency. in the deficiency in student loan servicer application. So this isn't provided for. You can see that I haven't filled in all the information. What we have done in the past is that if there is, if during the process of requesting a license or applying for a license, we don't get all the information we need, or there's some information that so I'll use consumer finance lenders as an example, because they're also in the NMLS system. If we have a consumer finance lender who comes to us and says, here's my application, here's my loan material, and their loan material is higher than 36% with regard to consumer finance loans, we'll set a deficiency on that, because under Oregon law, you can't charge more than 36% as calculated as an APR. So that's what the deficiency process is used for. It isn't a rejection of the student loan. It just lets everybody know that, nope, there's a problem here and we need to have it fixed. We found that it's useful for us to have an actual process for deficiencies, because a lot of times when we'll set a deficiency, I shouldn't say a lot of times, sometimes when we set a deficiency, we just never hear back. And unless we have some sort of provision that says, okay, if you don't get back to us in a certain period of time, we're going to cancel it, we have sort of floating applications out there that we need to track, and that becomes troublesome for us. So that's what the deficiencies is for, is just the process for being able to contest a deficiency set on a license application. Any questions? And then the branch office licensing. Again, it's for the NMLS, how it is that the licensing would proceed with regard to the branches, the form that needs to be filled out. I'm not sure how many branches are actually going to be there in this day and age of electronic things. It seems that we're moving farther and farther away from actual storefronts. And so it is possible that branch licensing in the future, I know NMLS is kind of discouraging branch licensing, that in the future the branch license may become moot. But currently, because it's provided for in the bill, it's provided for in the rules. And then the next 0030 is the renewal process, which again basically says it expires on the December 31st. That's provided in Senate Bill 485, and do the renewal the same way that you did the original application through the NMLS system. And then Karen, if you can scroll to 0035, the liquidity. So I took a guess here, and it's based on the other student loan servicer rules that I was looking at when I was preparing these. There is a net worth requirement, one of the things that's provided for in the bill, and I honestly don't know what is a reasonable number for the net worth. So I threw in 250,000, and that is based on, I think, Washington's, might be California's. I know I was looking at Connecticut's. Connecticut's is also $250,000. So I throw it out to the group. There is another, maybe Washington's is 300,000, or that could actually be their bond. But is that a reasonable amount? I see at least one nodded head, two nodded heads. Some pensive looks, a thumbs up. Okay. Well, then I guessed well. So that is going to be the liquidity operating reserve, the tangible net worth. And hopefully you can hear me, because I just got a bad network quality thing. That'll be the tangible net worth, then will, for the purposes of the rules, at least until we get through to the public comment, will be set at $250,000 unless something comes up that would indicate that that's unreasonable. And because sometimes we find cases where things are unreasonable, subsection 2 in there says that it just gives us the ability to waive it or to adjust it if we find that 250,000 is not reasonable. In particular, we find that when we're dealing with cryptocurrencies, and I don't know that there's a lot of loan services out there who deal with cryptocurrencies at this point in time, but that adjusting, I said money transmitters is where I kind of find my example for this. We have provisions for a money transmitter to have $100,000 worth of net worth, but we don't currently in our rule catch up with cryptocurrencies. And so how it is that you come to terms with that 250,000 is kind of is open, and it doesn't always reflect a sensible regulation for some smaller businesses. Fair enough? Okay. So 0040 is the corporate surety bond. Again, I don't see the amount is probably a little bit later. The bill provides for either a corporate surety bond or a irrevocable letter of credit. Many of our statutes do this. And again, I took just a shot from the examples that are currently out there. I know that there are bonds at 25,000. There's bonds at 30,000. I picked 30,000 because that was based on our neighbors to the north. But I really would like, and that would be, running to Oregon. So if you have, Oregon and Washington really right on top of each other, and there's a lot of back and forth with regard to commerce. So it's not that it would be 30,000 that would cover Washington and Oregon. The Washington's bond runs to Washington, Oregon's bond runs to Oregon. That's the same for all other states. So does that strike you as a reasonable amount for student loan servicers for this license? I'll take nods. I'll take hands up. I'll take frantic shaking of heads.
I think this is, but I will reserve, just to go back and touch base to confirm, but I think we're going to be okay with it.
Okay, thank you. Any concerns that it's not high enough?
I would say from an advocate's perspective, this is a pretty small industry of established players, and it's concentrated enough that it's not payday lending. We don't worry about companies folding and running out of state the same way that we would in other markets.
Great, that's good to know. Thank you. Any other comments on it? Okay. Karen, if you can flip us down. For the meantime, I'm going to save, do we not really going to have, oh, yes, we do. My work computer, since I don't go into the office, has not updated to daylight savings time. So it tells me now that it's 3:02, but I see in reality it's not. I was going to panic for a minute. So I'm going to flip back around to the fees payable kind of at the end when I know we've gotten through the rest of it, because it strikes me that the fees payable and how it is that we come to those fees is going to be something that we'll need some discussion about. So I would go to my second numbering error, which is the examination charges. Typically what the division does is $75 an hour. We often do book exams without having to send people to various places. Sometimes we have to send people to places, although not for the past couple of years. But 75 is what it is that we charge for all the rest of our programs. So that is what that addresses right there. I'm assuming there aren't any questions about that. Unless how we do it so cheap. Oh my gosh. Sorry. Okay, so the rules around the use of assumed business name. Assumed business name is one of those things that we like to have in the NMLS. There's a couple of our programs where we don't have it required in the NMLS, and that makes it very difficult for us when we're trying to look up a licensee, if we've got a consumer complaint or a consumer question, and we cannot find who it is that is doing business under that name because we don't have access to that information. The Secretary of State requires the assumed business name. It's not an onerous process at all. but we just want to make sure that that's provided for, and it's provided for on the in the NMLS in those particular forms. I don't know how many of you have ever gone into the NMLS. There's just these, fields that you fill out, and if you don't, then you get a deficiency, and within 30 days, we'll have it all fixed up. So unless there's any questions on that, then 0060, the financial responsibility, the criteria for the individuals. This comes largely from our, I think, mortgage servicing program. And one of the things that we find people get a little touchy about is how it is that we judge whether or not a person is of character to inspire the confidence of the community. It's kind of strange legislative language, and it's pretty squidgy with regards to what that means for financial responsibilities. So that's what this rule is trying to get at. And in particular, we will ask for a lot of things, but we are not looking to disqualify people unreasonably. And so, Karen, if you can scroll down a little bit. So we've got the outstanding judgments, the liens, foreclosures. But when you get down to subsection 3, what we're trying to clarify is that when we're assessing the financial responsibility, while we ask for this information, the bankruptcy proceedings, the foreclosures, we're not really, the mitigating circumstances, involuntary job loss, involuntary medical expenses, divorces, attempting arrangements with creditors, other factors that we don't believe, based on the rest of the information that we have in front of us, should actually disqualify somebody. That doesn't indicate to us that they wouldn't, have the confidence of the community. It just indicates to us that, yes, these things are there, but here's the reason that they're there, and it's not because we have any concerns about them taking, servicing money and running off to a place that doesn't have extradition. So that's what that rule is kind of getting at. Yes, we need to ask for these things, and no, they don't automatically disqualify you from a license. There's nuances there. So hopefully that is clear enough that it doesn't cause a lot of discomfort. If there's things in there that we can make clearer, or that really we should consider that we're not, that are real red flags that we haven't put down there, or red flag information that we need to know about that isn't actually accommodated for, then that would be something that we would need to know about, so that we're not licensing folks that are shady. But I think, as you pointed out, it sounds like we've got a, kind of a small field of established players, and we're not really, it's not the payday loan industry.
And this, just a question, I have to go
Sure,
back
sure.
and look at the statute, but so this is collection of information for individuals. Hold on, give me 1 second. This is tied into sort of the defined sort of roles. Pull it up here. I'm sorry.
Oh, no.
I just think this is for individual directors at the for the licensed entities. Yeah. Okay.
Yeah.
So I think one just thing to highlight that we've had challenges in other states. We do have some entities that are state agencies, and some of the directors and others. It's a challenge because they're appointed and by the governor, and so other states have done sort of exemption processes or accepted alternate information or something like that. You just may want to consider sort of that has been an issue in other states, because we have individuals who are, we're dealing with some of those, right, like I said, are quasi-government agencies or full government agencies.
That's a really good point. Yeah. That's not typically what we find with the rest of our licensees, but the student loan area is a little different, isn't it?
Yeah.
Okay, I'll see what I can do with regard to crafting that, and we'll revisit it when we come back at the next meeting. I don't know if you can hear my pencil scribbling. Okay. Karen, if you can scroll down. So then we get to the duties. Boy, my formatting on those numbers just gets worse and worse. The duties of the server of a student loan. And these were spelled out in the bill. So there shouldn't be anything in here that isn't in the actual bill. However, maybe there should be. I don't know with how familiar you are with other student loan servicer programs or with issues that have arisen that resulted in the bill. If there's things that are missing from this, maybe I'll take a moment to kind of just run through these. So we've got, except as otherwise provided under federal law or a loan agreement in a contract with federal government. So that's our preemption kind of out. That the student loan servicer has to assess against a borrower within 45 days any fee that they accept in credit or treat as credited to the borrower's account, all amounts the person receives to which the borrower has been instructed to send payments or notifications. I'm trying to see if I can skim it, but there's a lot there. The person must credit the payment or treat the payment as credit within 1 business day. So that's what I was looking for after receiving it, or notifying that they provide sufficient information. If you're scheduling it, and if they regularly schedule it before the due date, then it has to be credited not less than the scheduled due date. Correcting any errors promptly. Promptly is kind of squidgy terms, but I think we recognize it when we see it. Maintain adequate records for not less than 2 years after a final payment on a student loan. And then the records will be for each student loan transaction, communications with borrowers other than transactions, such as complaints, complaint resolution, and counseling, business records, including but not limited to board meetings and policy documents related to servicing student loans. And then at the request of the director, within 5 days, any records that we ask for, we're hoping that but the student loan servicer would provide. And then a person that services student loans may not directly or indirectly, and then we get into sort of the fraud pieces, employ any device, scheme, artifice to defraud another person, knowingly make an untrue statement of material fact, or a statement that in light of all of the facts would be considered misleading, obtain property by fraud or misrepresentation, knowingly misapply or recklessly apply payments to outstanding balance of student loan, engage in an act, practice, or business that operates or that the person intends to operate as a fraud or deceit, make or file with the department or cause to be made or file document that is materially incorrect or that they know to be materially incorrect. Fail to respond to a consumer complaint or to the communication from the ombudsman. One of the provisions of Senate Bill 485 is the creation of a student loan servicing ombudsman that'll be housed in the Division of Financial Regulation. I don't think we have that person on board yet, but so the student loan servicer can request in writing that the student loan ombudsman not allow more than 30 additional calendar days with which to respond to the request if a person explains why additional time is necessary. That's with regard to communicating with the ombudsman, whose job is then to communicate with students when they have issues, the back and forth. And then the catch-all that if someone loses their license, it does not extinguish their outstanding responsibilities to anyone. Any glaring omissions? Anything that seems unreasonable? Ellen?
Hi, I just have one comment. And again, I'm just filling in for Kate Dennison today, so I'm not a subject matter expert on this, and I don't do a lot of rulemaking. But I will say as the Director of Consumer Outreach that we don't deal frequently with complaints about student loans, but occasionally we do. So I'm just wondering about this statement here in F, make or file with DCBS. I'm just wondering if we should think about making that broader to just say make or file with a state agency, because in, you know, defense of some of these businesses, they might not know who they're dealing with, and it might not be clear. So I would just say that might be my only comment on that. And those of you who are much more knowledgeable about this than I am, feel free to chime in. But I know that we work very closely at the Oregon Department of Justice with DCBS and often share those complaints. And when it kind of gets down to the nitty gritty, you know, it can be unclear at times, like who's taking the lead on this. Like we just had the huge Navient case. So I'm just wondering if we should think about that piece. That's my only comment there.
Thanks. What does everybody think about that? Does that sound reasonable? I don't know that it expands much with regard to the requirement, but
It sounds reasonable to us.
That's fine. I don't think we would have any objection to that.
Okay. Well, this isn't the last chance anybody has to object, so.
Can I go back to one of the previous ones that you were talking about? So you might want to, notwithstanding the question of whether the automatic licensure regime is appropriate, I'll leave that. But to the extent that that is the case, or you believe you have that authority, the requirement of holding loan information for 2 years could potentially be very impossible for a federal servicer to do. That's federally owned data, and to the extent that a contract expires, they would transfer that data to someone else, right? So as is contemplated here, but then once that contract ends, they have to purge their system of all federal information. So you might want to look at that there, and I think we have no problem with the broad concept here, but there are going to be some cases on federally held loans where the contractor must purge its system of that data within that 2-year window.
Can you scroll to the top of that, Karen? Is this the one that we start off with the notwithstanding? Except as otherwise required. Okay. That is good to know, though. I didn't realize that upon transfer that Navient's going to have to ditch my information within a couple of months.
Yep. So as long as if you feel that completely covers it, I just want to raise that for your awareness as you all are thinking about this.
Sure. I guess the question is, do you think it covers it, or do your folks think it covers it? Because I would tend to read it that way. Yeah. But
no, I think the language you have is sufficient. I'm just highlighting that you're going to see some variation there as y'all are doing your oversight here.
That's a really good point. Thank you.
Can I suggest an addition here to the list of enumerated prohibited practices? Sure. You now license student loan servicers, and that means that DCBS has the ability to supervise for compliance with or enforce the prohibition on unfair, deceptive, and abusive acts and practices under the Dodd-Frank Act, federal law.
Yes, and that is something, you know, elements like that, because we also, with regard to consumer finance and things like that, a lot of that authority is shared. I think particularly under the Dodd-Frank Act, it's shared with the DOJ, but yes. So what would the inclusions?
I just dropped it in the chat. I think part of the reason why I think it makes a lot of sense to include something that just parrots back 5531 is that the Consumer Financial Protection Bureau's education loan exam procedures are heavily unfair, deceptive, and abusive acts and practices exam procedures. And so having a clear statement that DCBS is willing to supervise for compliance with and enforce the general prohibition on UDAP under Dodd-Frank will help your examiners be able to use the exam tools that CFPB's already developed. And make it very clear to your supervised entities that that's the expectation. And I will happily share, I think we've shared this with you guys before, but I will happily share again the most recent update of CFPB's education loan exam procedures that include a very substantial student loan servicing section for UDAP compliance.
Ellen, do you have any thoughts on that at all?
Mike is a lot smarter than me, so I would just say that whatever Mike says, I'm in agreement. That makes sense to me.
I'll write it into the draft, and it'll be something that we can go over, and it'll be there for discussion in the future.
Would just add OSPERG's support for that as well.
Thank you. Anything else on that provision, the duties? Sorry, I have a 12-year-old son. I'm about to start giggling. Can you scroll to 70, 0070? So the exempt entities, and this comes from the bill. So we've got financial institutions, holding companies, attorneys who are practicing law and just incidentally are kind of getting into student loan servicing. I don't know how that would work, but someday if I ever go back to private practice, I'll make sure that I know that that's there. Public bodies, public universities, community colleges, Oregon Health Science University, nonprofit post-secondary institutions, state agencies or nonprofit institution or organization that has an agreement with the U.S. for under the Education Act, solely for to the extent that the agencies, institutions, organizations, actions guaranteed that engages in averting defaults, and that's kind of based on the definition of what it is to service a student loan in the bill. It does not, that exemption does not extend to an agency, institution, organization's actions in servicing student loans, just to, acting as a guarantor and averting defaults. And then notwithstanding if the director finds that there has been a violation of federal law or unfair, fraudulent, deceptive, dishonest practice, then we can determine that those folks would need a license regardless of the exemption that they're. And that is provided for in Senate Bill 485. It wouldn't be something we could do if it wasn't provided for in the bill. Any other exemptions that we're missing?
No exemptions. I had a thought as I was listening to you explain the exemptions, and it's kind of going back to the other section. Is it the expectation that organizations such as document prep organizations would need to be registered in under this category if they're going to help borrowers make payments, fill out forms?
That's a good question. Let me pull up. So the definition of to service a student loan is to receive a scheduled periodic payment. This is from Senate Bill 485. To receive scheduled periodic payments from borrowers under the term of the loan, apply payments of principal or interest and other in accordance with the loan. And then this is probably the part that would get at: perform other administrative services with respect to a student loan, including but not limited to performing any of the following actions during periods in which a payment is not due, which would be maintaining account records, communicating with the borrower about the student loan on behalf of the lender, or interacting with the borrower to prevent default on a student loan to enable the activities described. I don't know that the document preparation would fall within any of those definitions.
Not complete. I don't think completely, but that's helpful. Thank you.
Anybody have any thoughts about that?
I think you're right, that I don't think it meets the definition. I had a question though about the part, I think it's on the next page, where it talks about if the director may require them to have a license if they've defrauded people.
Mm-hmm.
I don't really truly understand what that is trying to get at. Is that trying to address the situations we sometimes see, like in my world, it would be most akin to construction contractors. One of the issues we have with fraudulent contractors is we can't do anything if they don't have a license. So is this kind of addressing that issue, like, or am I missing something? It doesn't necessarily make sense to me. Why would we want people who have violated state or federal law to then get a license?
Actually have a license.
Yeah, but I'm guessing it's that scenario where, you know, they've defrauded the 89-year-old woman saying she has a bad roof, and now we can't do anything because they're not licensed. So maybe that's the workaround. Does anybody know?
I think so. You can just barely see at the bottom of the screen that 0075, the director of supervision, is granted to us regardless of whether or not somebody has a license. And so I think that gets at the construction contractors issue. And yeah, we get that too. It's like you can't charge me for unlicensed money transmission because I'm not licensed. It's like, no, that doesn't make sense. But
I also could you tell me, Karen, if I'm reading this right? I also read that as potentially overriding the carve-outs that are enumerated above. So, for example, if a company that has an agreement with the Secretary of Education to perform default aversion is found to have violated federal law, the director can then make them a licensee moving forward because their past bad practices present risks to consumers.
Yes.
And I think we are particularly, we'll provide written comments on that, but we are particularly focused on that as it relates to those so-called guarantee agencies providing default aversion, because the CFPB has open investigations into the two largest right now. And, you know, I don't know that that's going to turn into litigation, let alone a finding of a violation of law at trial. But like, there is reason to suspect that those firms are engaged in unlawful practices, and we should all be watching them closely. And it would absolutely make sense to us that Oregon supervise them if there's ultimately a determination that they're in violation of the law.
And
that's
I think,
really helpful. Thank you. That makes a lot more sense. So
thanks. Yeah, that is actually the first time I have seen that provision in a bill that lists out your exemptions, that there would also be that provision that says, okay, but despite that, if there's a finding that there's bad behavior, then you can license them. So I thought that was an interesting provision in the bill. Any other questions or comments on that one? Okay. So 0075, that's the director of supervision, essentially, that we can call up, you know, it doesn't matter whether or not you have a license. If you're doing this activity, that's what it is that we regulate, that we can ask for books and records. And then in particular, you'll see in 2B that the materials that we receive as part of an examination or enforcement action are subject to 705.137. That's the director's confidentiality statute that protects them in a case of public records review and things like that. So we've got the ability to investigate in-state or out-of-state, the subpoena, interviewing, that's sort of the boilerplate language for our supervision that we use. And then at 0080, the disclosure of significant developments. Essentially within 10 days of filing for bankruptcy, a control person being subject to an indictment, final issue or final order issued for another state. We want to know about that. If that final issue is a cease and desist, suspends or revokes, or constitutes a formal or informal regulatory action against a licensee. And then, so if 10 business days, if they cease doing license or business, and then if there's a change with the assumed business name. And then for longer term notifications, it's 30 days if you're closing, sorry, not you, if the licensee is closing its principal place of business or a branch, or if they're opening a branch that wasn't listed. Karen, if you can scroll down a little bit, I think there's a couple more. Oh, I still have a thing from a debt buyer application. Any, sorry, changes to the contact information, material changes submitted for through NMLS to the on the application, change of ownership, change of control, which would include somebody, a new person coming in with a 10% share or more, acquisition by managing partner. So it essentially can change of control persons. And that's generally, active or passive. Typically for passive owners, it is a, we want to know, but if you tell us that it's this is a passive owner who has absolutely no control, then it's a rebuttable presumption that they would have a control. Any questions on anything else that you think that a glaring omission in terms of, and we'll revisit all of this, coming back to the next meeting to kind of get a now that we've had a chance to think about it, and it's like, well, yeah, but that doesn't make any sense, or it should be, I think 30 days is pretty standard. But the displaying, if you want to keep scrolling down, Karen, we've got the display of the license. This is one of those old-fashioned requirements that folks used to have to display a license, and now that so much of it is done electronically, that requirement is met by posting it on a website. So we just want to make sure that, a prominent display of an actual license, we don't print out licenses anymore, but if the number is posted on your website where people can find it and then look you up, we can find it and look, I keep saying, then that meets the requirement. So it, just to be clear, we still have folks who are asking, do they have to display a paper license even though they don't have any branches, nobody walks in, it doesn't do any good to have a piece of paper stuck on the wall. It's like, nope, it's on the website that meets the requirement. So is that it, Karen? That looked like a bit of a wrap up.
Yes, that is it.
Thank you. So that's the general rundown, basic structure of the rules. Any kind of comments or things like, well, why haven't we addressed this, or this is missing, or just off the top of your head for the very first time you get to see these things and jump straight into it? Okay. Then I think maybe I'll take us back up to fees, if that works with everybody. There we go. So I have actually had two stabs at drafting these fee provisions. One is what you see here, which is just a straight up, you've got some sort of fee plus a investigation fee, or a branch fee, and then for late renewals, there's another fee, wasn't highlighted there, and then if we find out that you were late because COVID has shut everything down, we can waive that fee. I think, so one of the issues that we're having with regard to setting the fee, we have a few. One, we don't know how many people are doing business in Oregon, so we don't know what the fee would need to be in order to support the program. We get a sense that there are some very, very large players and then some fairly small players. And in that case, is it, equitable to set a fee that everybody pays the same, or is an assessment based on actual student loans, the portfolio, a more reasonable way to break it down? And then with regard to branches, typically what we do is you've got the one fee and then you've got half for the branch. In a day and age where branches are going away, where we don't know if we're going to have any branches, is that a workable structure? So with regard to how much we need to do the program, I can't answer that just yet. I don't know. I'm sure there are people here who do. But what is the sense for a flat fee versus an assessment? Any thoughts on that?
Well, this is Scott. So practically, I mean, I think, as you highlight, there's some large participants in this marketplace, and probably most of the smaller participants are regional, right? So that often means that you're going to probably have mostly licensing large entities and a handful of sort of small entities that are servicing. I think generally we think it's easier to do a flat fee. Obviously, that's dependent upon sort of, what the estimate of costs here are. But if it's, pure just, to cover the cost of licensing, I think that's probably going to get you to a fee that would be not a barrier to entry or sustainability for smaller participants, and is oftentimes just generally easier to administer. But obviously, sort of, y'all's assessment about sort of what the cost is to the state to run the licensing regime here. And you're probably not going to be licensing just more than, I think we did some rough numbers, probably it's not more than 35, could even possibly be probably the number that you would be licensing.
That's more information than I had with regard to licensing, how many people were likely to be licensed. So thank you, that's very helpful.
Yeah.
Any other thoughts with regard to? You guys are the easiest group. I'm gonna have to throw in more controversial provisions just so I can get a little.
I have a question for the group, if that's okay.
Thanks, Shelley.
I just out of curiosity, if anyone has an opinion on so California and Washington both do a licensing fee, and they also do an assessment. Washington, their assessment is on the adjusted total loan volume of loans in the year, and California actually bases their assessment on the number of borrowers. And so I'm not sure the difference between those two, and if there's any thought of one method over the other.
So I think from the industry perspective, the borrower measure aligns, especially on the federal side, with the compensation structure that servicers have today. So if you do it at a loan level, for some, you would create sort of a cost issue that would be disparate treatment between borrower base. So, I mean, I think if you're looking at that, it's definitely a different thing per loan and per borrower. I mean, obviously from a dollar basis, it sort of nets out, but I think per borrower is probably a more appropriate way if you're looking at an assessment. And plus, that's really the impact, right? If you're talking about sort of from a consumer perspective.
Thank you.
And as a rule of thumb, Scott, is it roughly between 3 and 4 loans per borrower for a typical one of your members?
I think that's fair. I think that's fair. Yeah.
It really, we budget 2.5.
Okay.
2.5. If it does fluctuate a bit depending on whether you're looking at graduates or undergraduates, but about 2.5. 4 is a little high. 2.5, 3.
Thank you. I have looked for information with regard to borrowers in Oregon, and I can find, roughly information about the number of defaults, but I'm not sure if there's a place that I can look that tells me this is how many Oregonians we have that are going to have loans outstanding, that's our population that this bill directly impacts. And I know that kind of changes every year with regard to enrollment and whatnot, but is there a source for that information?
Federal Reserve Bank of New York uses consumer credit panel data that provides a state-by-state look. That's okay. It's not great. The administrative data the Education Department releases is also okay, but not great, and is also limited to federal student loans. I think the state-by-state might actually be only federally held student loans, but Will or Scott probably knows better than me. If you ask the CFPB, though, I suspect they would just give you this information, that at the very least, they probably have this for the largest servicers in some kind of more comprehensive way, but I don't know how far along they are in you know, they collect this on different cycles, and so maybe they have not actually market sized it. I know, Will, you're making a face. You probably have.
Yeah, it's difficult because do you want the data at the point of origination when they're going to school? Do you want the data at the point of graduate, at the point of origination when they're going to school? Do you want it when they graduate, or do you want it a year into repayment? Because if they move out of state, do you still want to track them, and would you still consider them, right? So there is some variability there in the data, and especially if you've got really strong cooperation agreements between Oregon and Washington, you could have a lot of folks that live in Washington come down, go to school in Oregon, and then bounce back up to Washington. So, there's a lot of factors that come into play there. And so it is very fluid when we decide to look at the portfolio and say, all right, stick a pin in it. As of today, tell me who has an Oregon address and also has a student loan. And, we also have challenges, and Mike and Scott are aware of this, obviously, because folks who move may keep their Oregon phone number, which causes a whole nother kind of, challenge. So it just kind of depends on what baseline you want to use for your measurements.
Okay. That's good to know. I thought maybe I was just overlooking an easy source of information, and why couldn't I find it? But and I honestly hadn't, I know that new loans are taken out all the time at the beginning of the semester, quarter, or what have you, or paid off at any given time. Maybe not within the past couple of years, but I hadn't really considered that with regard to how it is that an assessment would work and where it is that we would be looking at the number of borrowers, at the very beginning, at the very end, a year later, and how mobile they might be. So thank you for that. Is there, so go ahead.
I was just going to say, and going back to this, I mean, the FSA does have on the federal side, data center, you can go look. I mean, they have, I think Mike's right that it's not, their data sets are not particularly refined. Maybe that's my kind way of saying it.
It's a very kind way.
But I think, roughly probably you're looking at somewhere around north of like 540,000, I think, borrowers in Oregon. So somewhere around there. And that's obviously just federal loans, but, tack on another, most of those folks are probably going to have, if they have federal loans, if they have private loans, they probably have federal loans too. So that's probably not going to move the borrower count very much.
Yeah. Okay. Thank you. So that is my real rough rundown of the draft rules. There are a couple of things so this is how I would like to proceed going forward. I will take the suggestions that you have given me, and the questions, and I will go in and kind of tweak the rules with little comments. We'll be able to see exactly where I've done it. I'll use the track changes. I find that's easier so that they don't get hidden. And then I will submit that out to you guys so that you get a chance to kind of look and comment on that. I would like very much to get back to you when we actually have a proposal for the fee, when we've been able to do our fee study. And I don't know exactly what time that is. I would wager that there's a fair number of people on this meeting who will not really be able to make a February meeting very easily. that at least among the local folks. But I can try for a late February meeting if that works with people. And that way, like I said, the thing for me is to get these in a publishable form. They'll still be draft until we go through the notice and comment period and then the formal adoption. But I would really like to get the draft proposal out there so that folks know what's coming, have an opportunity to comment and have an opportunity to prepare, if that works with everybody. So I would like to shoot for a late February meeting. The legislature should be largely wrapping up by then, if that works with. And Charlie, I'm looking at you because you are in committees all the time, and
yeah, no, I think that should work.
okay. So
Yeah,
we'll
late
try.
February, fine. Yeah.
Okay. So I'm not going to wait until late February to get out a draft of the comments and what I have heard, and if possible, if we can do a little bit of this on over email. So if I can send you the next draft that incorporates what I have heard and hopefully incorporates it correctly, and then we can do some back and forth. If you want to all like individually go over that draft, probably won't have it done for at least a week because I have a legislative session coming up. And submit any comments that you have on the document to me. I can, put those all together into one big comment document, and then we'll all be able to see the ins and outs on stuff. And then when we get back together in late February, we can discuss all those comments. Does that sound reasonable to folks? There's I see a couple nods. Okay. I'm going to take that as good. I've got public comment on my agenda, well, on the agenda that Karen has so gracefully put up for me. I don't know that we have any members of the public who aren't actually expressly on the RAC at this point. But if there are, now's your chance. Not so much.
I did not identify myself as an Oregonian at the top of this, but I do live in Portland, and so to the extent that helps, I am also a student loan borrower from Portland, in addition to a member of the RAC.
So I know there's at least two of us at this point. Okay. So then, if that works for everybody, then the recap. There we've been. Thank you very much for your help. I'm going to take your comments. I'm going to give them back to you, and you can get them back to me, and then I'll get back a general comment document to everybody so that it's not everybody having to sort back and forth everybody's comments. It'll just be one document. The next thing that we will have to do that doesn't actually involve the terms of the rules specifically is a fiscal statement that goes over what the fiscal impact of the rules will be. And that is different than the fiscal impact of the bill. Fiscal impact of the bill says you have to get a license. And so, yes, we know that whatever the license is going to be is going to cause an impact to businesses, but that is part of the previous impact. So there's a housing statement if it's going to impact housing, if it's going to impact small businesses. And there's a new requirement with regard to vulnerable populations. And I'm not, Karen, you want to go over that a little bit? Because that's
yes. Here, let me get this thing off. So there was a bill passed and last session, and we are to, as a committee, come up with a racial equity statement. So how this rule or set of rules may or is likely to affect different communities. That's probably the best way I can state that. I have not gone over this with the policy analysts. We're still trying to wrap our hands around it. So, but it is a new piece that is required from all state agencies on our notices, notice of proposed rulemaking. More to come. And I do see Shelley has her hand raised.
I was
Or
just,
did.
I was only just going to ask you and Aaron, I have a couple of questions, and I wonder if you guys could stay on after.
Okay.
We will be able to provide specific questions that we're asking for the fiscal and for the racial equity statement,
Yes.
so that it's not just a real broad, well, what am I supposed to say? But there are specific considerations, and I will send that out when I send out the comment document as well, so that we've got that in our head while we're looking at the rules for the next time.
Can I ask an extremely ignorant question about the racial equity impact? Is that the impact of the administrative burden on the rules as it relates to racial equity and industries that you regulate? Or is that the racial equity impact of student debt and improper loan servicing on people of color that have student debt?
I
I'm going
believe
to
it's
suggest
just
that
the
it's
rules.
the rules. Yeah.
Yes.
Okay.
Yes. And I will also look for a meeting the last week of February and send out a invite for that.
Then if there isn't anything else for the good of the order, I will
Aaron,
release you to the wild. Oh,
I'm sorry. I do have one quick question, and maybe
Sure.
I can talk to Winston offline. When we were having the conversation about the data being collected, I thought you were sending a link about showing like what information is publicly available. Is that separate from the information that is being gathered? Do you understand? Does that make sense?
Yeah, and I was actually just responding to you in the chat, so thanks for raising it while we have time. So the link I sent is the reporting requirements. It's the framework for what data is being gathered. Because that first round, and I guess the second round also, were during COVID, they pretty significantly modified what was going to be requested just to reflect all the moving pieces. And so also haven't figured out what their public reporting regime is going to be. So I suggest reaching out to DFS to ask about that. They do an annual report of sort of high-level complaints and other data, but that was something they were collecting already. So the introduction of this portfolio-specific data was still being developed as I left. And I think it's been less than a year since I left, so they haven't sort of done anything new that I've seen externally. But the lack of reporting wasn't yet a firm policy decision. It was just caught up in all the COVID and standing up of the new licensure squishiness.
Okay, thank you. That's very helpful.
definitely been a squishy couple of years. Great. Thank you so very much for your time. I really, really appreciate it. I will be in touch soon with the changed draft that we can comment on, and then I will see you in about a month. And until then, stay safe. Thank you very much. And if you have any questions, feel free to reach out. I'm always at my email because I live there now. So, thank you.
All right, thank you.
Thanks, everybody.
Shelley, did you need me for the after call, or are you good?
Good. What I was just going to ask is on the rulemaking. So the part about the ombudsman and all those responsibilities, we don't need to do rulemaking on that because it's so clearly stated. I'm assuming in anything we develop, we can just do like procedurally, because I know like part of the fiscal on this is like an education program, which it states that we can do via a vendor. And I just wanted to make sure there wasn't anything on those parts that we needed to fold in. I don't know that there is. That's why I didn't want to like bring it up in front of everybody.
Karen,
But
do you want to stop the recording?
Oh, sorry. Thank you.
It's not a big deal, I don't think.
Hang on. Totally forgot about that.